How's everything? Talking about legal stuff today, so I guess you're here. Everybody's here. Yeah. So my role in the mission, I have budget the team knows. We're gonna need some legal aspects or something, or if it's particular, like lawyer was a file for us. Otherwise, so Jennifer, the setup, that's what it said.
Declaro abierta la sesión número.
I call to order the 10,170th meeting of the Security Council. The provisional agenda for this meeting is the following item: International Residual Mechanism for Criminal Tribunals. The agenda is adopted. In accordance with Rule 37 of the Council's Provisional Rules of Procedure, I invite the representatives of Bosnia and Herzegovina, Rwanda, Serbia, and the United Republic of Tanzania to participate in this meeting. It is so decided. On behalf of the Council, I welcome His Excellency Mr. Emmanuel Ugirashe Buja, Minister of Justice and Attorney General of Rwanda. In accordance with Rule 39 of the Council's Provisional Rules of Procedure, I invite the following briefers to participate in this meeting: Judge Graciela Gatti Santana, President of the International Residual Mechanism for Criminal Tribunals, and Mr. Serge Bramertz, Prosecutor of the International Residual Mechanism for Criminal Tribunals. It is so decided.
Muchas gracias.
Thank you very much, Mr. President. Please allow me to congratulate you for assuming the presidency of the Security Council and wish you my constant support and thanks to you, to the Council, from the International Mechanism of Criminal Tribunals, in particular in the current context of the review of the mandate of the mechanism. It's a privilege to take the floor at the Council on behalf of the mechanism and present the sixth report of the mechanism that includes the strategic plan and its 28th situation report.
Mr. President, Excellencies, ladies and gentlemen, the future of the United Nations responsibility towards those within its duty of care, and indeed the future of international criminal justice, now stand before the Council. The Council created the mechanism to discharge this responsibility and to preserve the unprecedented success of the tribunals for Rwanda and the former Yugoslavia in delivering justice in the aftermath of atrocity crimes. The mechanism has effectively executed its mandate thanks to its dedicated judges and staff and the cooperation of member states. As history teaches, the moral arc of justice is long, and as the Council considers the future of the mechanism, it is worth reflecting or otherwise accounted for. Through decades of committed bilateral and multilateral cooperation, hundreds of international arrest warrants were executed by states. States respected privileges and immunities granted to both prosecution and defense counsel to allow for effective investigations. Thousands of witnesses, many granted judicial protection and the powers you provided under Chapter 7 following agreements between states and the United Nations, over 100 convicted persons served their sentences in numerous enforcement states. The last hearing in the last case, earmarked for trial before the mechanism, recently concluded, with a referral of one of the final contempt cases to a national jurisdiction. Only limited but still essential work remains. Thanks to the Council's enduring support, international criminal law is now fixing the public component of reconciliation and durable peace. Today, the Council is engaged in its sixth review of the mechanism's progress of work. To assist the Council, the Office of Internal Oversight Services, or OIOS, submitted its reports on the methods and work of the mechanism. It concluded that despite steep resource reductions of over 40% in budget and staffing since 2021, the mechanism has continued to deliver results across all its mandated functions. OIOS also observed that member states affirmed the continued necessity and relevance of the mechanism as constrained opportunities for consolidation and cost savings. Building on OIOS evaluation and the reports of the Secretary General of 1st December 2025, the mechanism's principles have developed and shared with the Council an mechanism functions and the institution's substantial reorganization and physical consolidation to meet its projected workload. To put the scale of this proposal into perspective, the mechanism following such changes expects that it can achieve a nearly 90% reduction of staffing resources, that the President and the prosecutor could serve on an ad hoc basis, that the registrar's position will be downgraded to reflect the significantly reduced scope of activities and responsibilities, and that the mechanism would operate from a single location. Mr. President, aligned with the recommendations of the Secretary General, the strategic plan proposes the transfer of assistance to national jurisdictions and denial. Such technical activities need not to be embedded in a court. The strategic plan also supports the Secretary General's proposal that the day-to-day supervision of conditions of imprisonment, a largely administrative function, can be transferred to enforcement states, provided that international standards are maintained. In this respect, the mechanism has made substantial progress in preparing for this possibility. All current European enforcement states, namely Belgium, Estonia, France, Germany, Norway, and the United Kingdom, have confirmed that there are no practical or legal barriers to assuming this function. The United Kingdom and Poland have further confirmed their willingness to serve as temporary detention states should the need arise in the future following the closure of the United Nations detention unit in The Hague. Relatedly, Rwanda, with which the UN has an enforcement agreement, has indicated its willingness to enforce sentences of persons convicted in proceedings deriving from the ICTR, and that it has the capacity and resources to do so in line with international standards. Consideration of this possibility is ongoing and will require confirmation that all necessary guarantees for the protection of the fundamental rights of the convicted persons are in place. The mechanism expresses its profound thanks to these member states and acknowledges their essential role in and substantial contribution to international justice. Be carried out by states and are no longer required at international level to protect the interests of justice and due process. Madam President, the strategic plan identifies a limited number of key judicial functions that should remain at international level to ensure the responsible conclusion of the justice cycle. These include judicial functions related to transfer and release of prisoners, a convicted person's right to relief to avoid miscarriage of justice, witness protection, non bis in idem, and the power to refer, monitor, and revoke cases. These issues concern the rights of convicted persons, the continued judicial protection of victims and witnesses, and the preservation of essential legal safeguards arising from the mechanism's duty of care to those over whom it has exercised criminal jurisdiction. They implicate core principles of legality, equality, and due process, which are the bedrock of international criminal justice. Their retention at international level is essential to consistent application of the law, legal certainty, and fairness. The recommendations before the Council are comprehensive and the result of exhaustive consideration by the mechanism of it being a small, temporary, and efficient institution. I must stress that legal certainty and continuity are key considerations for the Council as it deliberates on the forthcoming resolution. I take this opportunity to highlight a specific function under the purview of the President. Specifically, the mechanism supervises the sentences of 36 persons in 8 enforcement states and 2 persons detained in the United Nations Detention Unit. All prisoners, even those sentenced to life imprisonment, may become eligible for early release. In addition, the average age of our prisoners is 72 years, and it may be expected that release based on for release based on humanitarian grounds can arise at any moment. The continuous and active ability to adjudicate such requests is a guarantee that cannot lapse. The Secretary General's reports and the strategic plan uniformly support retaining this core judicial function among international judges. There is consensus that this function cannot be effectively transferred to states or the Secretariat. The Secretary General and the strategic plan propose that this function remains within the mechanism. This is by far the preferred option. It is the most cost-effective and efficient when considering the resources required to create something anew. More importantly, underlying conflicts and sentencing procedures. As noted by the Secretary General, this function is not cost-intensive. A resolution before the end of this month is key to ensuring that the UN's duty of care to those who have been imprisoned under its authority is effectively continued and implemented without gaps or legal uncertainty. Finally, and in connection with this function, I am aware that a recent decision on early release for Mr. Ratko Mladic has been raised applied the general principles of law. I take this opportunity to emphasize that credible justice depends on judicial independence without undue political pressure. This is necessary to effectively implement international conform to clear or finite timelines. However, the strategic plan, which balances principle and pragmatism, presents the Council with a viable path towards the responsible completion of the justice cycle. It entails substantial change while recognizing that the final phase of the justice cycle cannot be completed by relinquishing the guarantees that give international justice its legitimacy in the first place. The mechanism stands ready to continue to impartially and efficiently execute these obligations on the Council over 50 nationalities and have effectively implemented the international community's will to achieve durable justice. Time and again, they have reaffirmed this commitment, notwithstanding continuous professional insecurity. Their excellence and accountability are admirable, and I extend my profound gratitude. I look forward to hearing your views and continue to engage with you. Thank you very much.
Muchísimas gracias.
Thank you very much. I thank Judge Gatti Santana for her briefing. I now give the floor to Prosecutor Serge Brammertz for his briefing.
Madam President, Excellencies, thank you for the opportunity to brief you again. The details of my office's activities and results are set out in my written progress report. My remarks today will focus on the Council's review of the mechanism. Madam President, Excellencies, for the last 18 years, I have had the honor to be entrusted by this Council to serve as prosecutor. I've always shared my opinion in a transparent way, which is even more important when this Council is considering strategic and institutional matters. Also, so I would like to share my analysis of the situation, hoping it will assist your deliberations on the way forward. Madam President, Excellencies, through the ad hoc tribunals and mechanisms, the Security Council and the United Nations have achieved an unprecedented record of accountability and justice. 154 perpetrators convicted, no fugitives at large. Through their cases, the tribunals and the mechanism establish the truth of what occurred in the former Yugoslavia. Record is clear that across the conflicts in the former Yugoslavia, civilians were deliberately targeted in violation of the most fundamental rules of international law, while genocide was committed in Srebrenica. Finally, the completion strategy adopted by this Council ensured that international justice was temporary and not the end of the accountability process. Primary responsibility for prosecuting the remaining crimes has passed to member states who have demonstrated their willingness and capacity to carry this work forward. The results are a testament to the United Nations commitment to justice and accountability. Madam President, Excellencies, the Council has made clear its expectations that the mechanism bring its activities to an orderly closure. In this context, the mechanism's strategic plan is a roadmap for fundamental change. It is a proposal for the Council to start from. The core point is that the strategic plan reflects a commitment by all principles. We are ready to move forward in a new way with a fresh requirements. From my perspective, there are three essential components to address. First, those persons convicted and serving their sentences. Second, assisting member states to achieve more justice for more victims. And third, education about what occurred and remembrance of those who suffered. Madam President, Excellencies, the tribunals and the mechanism were mandated to prosecute individuals and hold them personally responsible for their crimes. Their guilt is theirs alone. Their punishment is for what they did, the crimes they committed. Not collective responsibility, but individual criminal responsibility. They were sentenced to terms of imprisonment and detained on the authority of the United Nations and the Security Council, enforced by member states in their national systems. Imprisonment is the most severe sanction that can be imposed under international law. It expresses our shared condemnation of these crimes. As prosecutor, I believe that the mechanism should continue to bear ultimate responsibility for convicts serving their sentences. Their imprisonment is by our authority and decisions. According to the statute, convicted persons are entitled to consideration for commutation and early release. Our system of justice provides them with the opportunity to demonstrate remorse for their crimes. The Council decided in Resolution 1966 that the mechanism was best placed to deal with these matters. That was the right decision then, and it remains so today. So I would strongly recommend that the mechanism continue performing the early release function as its core judicial and prosecutorial activity. Madam President, Excellency, as I have regularly briefed you, I believe that one of the most important achievements of the completion strategies has been that member states fully assumed responsibility to continue the accountability process. International justice was always a temporary measure in the particular circumstances of the time. Today, national ownership of the justice process has been restored, and member states have achieved and continue to achieve impressive results. In Rwanda and the countries of the former Yugoslavia, domestic courts and post-conflict justice mechanisms have prosecuted thousands of perpetrators for their crimes. They have delivered justice to victims where it is the best served, in local communities most accessible to the public. In addition, trials have been held in many other states around the world where perpetrators have fled. More than 1,000 genocidaries. In the country of the former Yugoslavia, more than 2,000 suspects still need to be investigated. Key challenges include complex cases against senior and mid-level perpetrators, crimes of sexual violence, strengthening international cooperation, and tracking fugitives. As IOS reported in the most recent assessment, member states consistently underscored the practical indispensability of my office in supporting their work. Achieving justice in their courts depends on the evidence and expertise my office provides. The obvious solution is to transfer this function to the United Nations Secretariat. As a technical function, this work falls squarely within the core competences of the Secretariat. The United Nations serves member states, particularly by providing international expertise to strengthen national capacity. My office prepared a clear and detailed proposal with budgetary and administrative implications, and is ready to discuss timelines. And so I would strongly recommend that the Council transfers this mandate to the Secretary General, together with our evidence collection and some of my staff members. Madam President, Excellencies, the work of the Tribunal and the mechanism is not just about the past, but also the present and the future. The victims and survivors have always been at the forefront of our efforts. We have endeavored to provide them with some measure of justice for their pain and suffering. Equally, though, this work has increasing relevance to the next generations. For many, the conflict in the former Yugoslavia and the 1994 genocide against the Tutsi in Rwanda are a matter of history, not lived experience. It is critical that the stories of the victims and survivors live on. It is by remembering them that we honor them. The mechanism archives have an essential role to play. The records of our trials contain the testimonies of so many courageous victims and survivors. They confronted those who wronged them and told the truth about what happened. This truth is needed now more than ever. Unfortunately, the denial of the crimes and glorification of war criminals persists. Reconciliation depends on full respect for the suffering of all victims from all groups. Memorialization is also vital to prevention. The horrific atrocities in Rwanda and the former Yugoslavia were not random outbreaks of violence. They were the result of organized plans by senior leaders who abused their authority and thought to achieve their political goals through the widespread commission of crimes. Hate speech and propaganda prepared the groundwork by dehumanizing other groups as foreigners and threats. Education about what occurred helps identify warning signs for the future, and it contributes to preventing future atrocities. So I strongly recommend that the archives of the Tribunal and the mechanism are transferred to the Secretariat so it can make them available to the public in the long term. This will ensure that the legacy of the tribunals and mechanism lives on for generations to come. Madam President, Excellencies, in conclusion, there is a path forward this Council can endorse. Addressing the three elements I have outlined will decisively advance completion of the mechanism's activities in a responsible and appropriate way. Transferring the assistance function and archives to the Secretariat will ensure Member States and the global public continue to benefit from the work of the tribunals and mechanism. What will remain with the mechanism can be the minimum possible that will create a sustainable foundation for the final essential work. The Council has provided its steadfast support to the tribunals and mechanisms since their establishment. Thanks to that support, many victims in Rwanda and the former Yugoslavia have received the justice they deserve. My office stands ready to assist the Council in its deliberations and provide any information that Council members may find helpful. Thank you for your attention.
Doy las gracias.
I thank Prosecutor Brammertz for his briefing. I now give the floor to those council members who wish to make statements. I give the floor to the delegation of the Democratic Republic of the Congo.
Madame la Présidente,
Madam President, the Democratic Republic of the Congo thanks the Republic of Colombia for convening this important meeting. We welcome Madam Graciela Gatti Santana, President of the International Mechanism, engaging in the residual functions of the tribunals, as well as Mr. Serge Brammertz, prosecutor of the mechanism. My delegation thanks them for their briefings, as well as the detailed information brought to the attention of the Council this morning. Madam President, the Democratic Republic of the Congo takes note of the progress report on the functioning of the mechanism as presented this morning, created by way of Resolution 1966-2010. The mechanism now is at a pivotal moment of its existence. This stage invites the Council not only to assess the progress made, but also to reflect with a sense of responsibility on the challenges that remain. Above and beyond its institutional dimension, the mechanism reflects a fundamental reality. Its existence is testament to, on the one hand, the ability of humanity to commit the most abject atrocities, as well as, on the other hand, humanity's determination to fight effectively against impunity and upholding law and justice. The successor of the work of the International Criminal Tribunal for Rwanda and the International Criminal Tribunal for the former Yugoslavia, the mechanism remains one of the most significant expressions of the commitment of the international community to international criminal accountability. Madam President, 16 years after it was created, the information presented today show substantial progress made in the implementation of the mandate entrusted to this body by the Council. It's evident at this stage that the main criminal procedures that come under the mechanism have now been concluded, and this evolution is an important step in the life of the institution, and it shows that today it is playing a more limited role, and this, of course, is in line with its residual mandate. Yet, as underscored by the most recent activity report, there are still some very important functions that remain. In particular, the management of the archives, assistance to national jurisdictions, the protection of witnesses, the supervision of enforcement of sentences, as well as certain judicial functions that continue to require particular attention. Furthermore, my delegation takes note of the work engaged in within the framework of the 6th biennial review of the mechanism, as well as the different assessments provided to the Council. These contributions are useful elements to guide the collective reflections of the Council on the future of the institution and on the most appropriate ways of supporting it in its institutional evolutions. In this regard, there are several questions that require our particular attention. First of all, the preservation, management, and accessibility of the archives. finding and national procedures that could still require access to these resources. The second is the assistance provided to national jurisdictions. This function remains essential for supporting the efforts undertaken by states to fight impunity and to preserve the achievements made over the years by the international jurisdictions. Thirdly, there are certain residual put into place by the Council for victims, witnesses, and also the individuals that are currently serving their sentences. Finally, it's necessary to fully take account of the role played by states who have been cooperating for many years with the mechanism, in particular in the area of sentence enforcement. In this regard, my delegation wishes to underscore the important for our deliberations to be guided by a double imperative to preserve the achievements of international criminal justice, while at the same time supporting with a sense of realism, lucidity and responsibility the changes to the mechanism in line with the spirit of consensus, shared responsibility, remaining true to the principles that guided the creation of the international tribunals and the mechanism itself. Thank you very much.
Agradezco.
I thank the representative of the Democratic Republic of the Congo for your statement, and I now give the floor to Liberia. The representative of Liberia, you have the floor.
Thank you. Thank you, Madam President. Liberia extends its appreciation to the President and principals of the International Residual Mechanism for Criminal Tribunals for its 6th review report, which includes a comprehensive strategic plan intended to inform these deliberations. We also happily welcome His Excellency, the Minister of Justice and Attorney General of Rwanda, as well as other distinguished colleagues to this debate. We are pleased with the Secretary General's report and recommendations, as well as the evaluation by the UN Office of Internal Oversight Services. Madam President, these reports, recommendations, and assessments signify that we are truly at a pivotal stage in our joint pursuit of accountability and justice for the gravest crimes, reflecting both the legacy of that the establishment of the mechanism in Resolution 1966 of 2010 was a landmark in ensuring that the closure of the ad hoc tribunals will not seek General and OIOS's evaluations, honors this mandate by proposing ambitious but yet pragmatic timelines for the transfer or completion of residual functions. administrative, and support functions to appropriate UN structures. We note, in particular, the intention to conclude outstanding mandates, including the investigation of past tribunals. Liberia supports the retention of key judicial functions, referral monitoring, and relocation, as well as witness protection. In accordance with international human rights law. Madam President, we are also mindful of the human rights obligations engaged to applicable international human rights and humanitarian law standards throughout the completion and transfer of the mechanism's functions. A necessary roadmap for the orderly completion of its historic mandate. As we assess the path forward for the transfer of the IRMCT's functions,
Doy las gracias al
I thank the representative of Liberia for your statement, and I now give the floor
very verbose. However, the key element, namely clarity on the timelines for the final closure of the mechanism, is still absent from them. ICTR and the residual mechanism continuing their activity have been in existence for more than 30 years. Whereas the Nuremberg tribunal was functioning for 11 months. And after its closure, as a single vision of the mechanism's leadership regarding its future. Such a plan could have been seriously considered about 15 years ago. Now it looks like a direct and undisguised disrespect towards the Council which originally established the mechanism as a temporary structure. The problem is that this is their work by 2015. The creation of the residual mechanism in their presentation was supposed to further accelerate the process of the tribunal's final closure. Prolong its existence. Whether we should believe the forecasts and promises of the strategic plan, the question is rhetorical. On a separate note, in this regard, it is not surprising that the strategic plan prepared on such a basis presupposes, in essence, the further functioning of the mechanism Thus, in the latest semi-annual report of the mechanism, the death of Mr. Kabuga in a hospital in The Hague is linked with the final completion of the last case concerning core crimes pending before the mechanism. At the same time, already in the report of the Secretary in connection with the fact we would like again to remind the UN Security that the UN Security Council originally established the structure as residual and temporary, and its closure has been excessively and unjustifiably delayed. Two years later, there is still no talk of completion in the mechanism's reports. The leadership of the structure continues without justification, requesting extension of its mandate for another 24 months. Concrete decisions have long been overdue on the completion of residual functions or their transfer to new recipients, which would allow closing of the mechanism, especially since the leadership of the mechanism itself constantly asks functions, many of which, by the way, I would like to recall, exist only on paper. And here, please allow me to provide a number of clarifications. Persons, for example, the rights of Mr. Karadzic in a British prison. Nothing specific was done by the mechanism to stop such violations. Wasn't interested side is taken on faith without the slightest attempt to establish an objective picture. Against the background of an absolutely negligent attitude of the mechanism to this function, together with a function of monitoring their conditions of detention. Another function, references to which the mechanism tries to justify its further existence, and it is the early familiarize themselves with the content of our letter on this matter, demanding an immediate release of the Serbian general and giving him the opportunity to spend his final days in his home country. Since we circulated this letter as an official document of the Security Council, I will only recall its main such condition. The reasons which he uses to explain the refusal to apply a similar approach to Mr. Mladic are beyond not just justice, but also elementary humanity. The president tries to draw an artificial distance at death's door. There is a continuation of a politicized anti-Serb bias permeating all activities of the ICTY and the residual mechanism. To extend the existence of the mechanism is simply not serious. Another function is witness protection. To an outside observer, not witnesses among Serbs were being intimidated and systematically killed. Officials of the ICTY merely shrugged their shoulders, declaring their lack of ability and instruments to ensure their safety. At present, the issue concerns exclusively the so-called about witnesses for whom non-disclosure decisions had previously been adopted. And here, I would like to point out all of these three functions two other quasi-judicial functions are non bis in idem, in other words, preventing double conviction for the same crimes and transfer of of convicted persons from one state to another in order to serve the sentence. This of implementation of these tasks. At the same time, we have taken note of the position of a number of council members advocating for preservation of quasi-judicial functions at the international level. Of the UN Secretariat. And such a person could very well tackle such issues. Together with a strictly limited number of experienced staff of the Office of the Prosecutor of the Residual Mechanism. We support access to them to all interested persons. At the same time, we are in favor of making them as public as possible, all of the archive materials, including placing them in open We count on constructive consideration of our proposals by colleagues in the Council so as to develop optimal solutions that will avoid accordance with the understanding which we have enshrined in the President of the Security Council SPRST 2015/21, its results, the results of the review, must be reflected by the Security Council in long ago. But we would like to also functions without a decision of the Council is already a practice, existing practice. We have seen several examples of that, so this is an option that we have. At the same time, we stand ready to work together with all members of the Council so as to make the decision. Secretary General to appoint a Ugandan judge to a vacancy in the judicial roster. We remain unable to understand why this is done a year after the vacancy arose, and literally on the part of the Secretary General, and in the Council as a whole, there is still no consensus on this. In general, we believe that the fate of judges and the roster will close the ineffective, unwieldy, and extremely costly structure called the residual mechanism. This issue is acquiring particular relevance against the background of personnel and financial cuts taking place across the UN system within the Secretary General's UN 80 initiative, which is affecting the permanent, not temporary and residual functions. I would like to, in conclusion, the delegations with the UN is of the view that the structure has been closed a long time ago. I thank you.
Doy las gracias.
I thank the Russian Federation for your statement.
For their briefings and for the comprehensive overview they provided on the progress made in implementing the mechanism's residual mandate. We also welcome the and we commend the contribution the two tribunals have made to international criminal justice. Here, the Kingdom affirms that the international community needs to address the root causes of these plan, including proposals for completing certain functions, transferring others, and reducing the size of the mechanism and its resources. The Kingdom also appreciates addressed within the framework of the draft resolution on the mechanism's periodic review by the end of this month. In this context, the Kingdom stresses the importance of adherence to the mandate set out in Security Council Resolution 1960. Taking into account the requirements of efficiency and rationalization of resources, while ensuring the completion of judicial functions, the integrity of remaining legal proceedings, and the preservation of the credibility of the judicial legacy, including transparency and order. The enforcement of sentences and the preservation of records and judicial archives and their availability in accordance with the agreed frameworks. Madam President, the Kingdom of Bahrain considers that effective and released persons in a manner that ensures respect for their rights, dignity, in accordance with international law. In conclusion, the Kingdom of Bahrain affirms and balanced vision for the future of the mechanism, one that ensures the efficient and transparent implementation of its remaining mandate, as well as the rationalization of its resources and the completion of its core tasks
Madam President, I thank the President of the International Residual Mechanism for Criminal Tribunals, Ms. Gatti Santana, and the prosecutor, Serge Brammertz, for their briefings and the Emmanuel Urega Shebuja, and the presence of the representatives of Serbia, Bosnia and Herzegovina, Tanzania, and Croatia. Madam President, the first thing that emerges from the briefings and the report is that the mechanism has performed and as recently as yesterday at the meeting of the informal working group on international tribunals, the Council has been conducting the biennial review provided for in Paris. History, that of the tragedies that occurred in the former Yugoslavia and in Rwanda, and that of the response given to them by the international community by creating the ICTY and ICTR. Through by bringing to trial the perpetrators of the most serious crimes, they marked an essential step in fighting against impunity. To be responsible and to live up to history implies that as long as there are people convicted by these courts, there must remain an and as long as there are witnesses, it will be necessary to rule on the conditions that allow them to cooperate with the courts, in particular, the responsible for today for prosecuting the perpetrators of crimes. And this assistance function the Council's responsibility also exists with regard to memory and future generations through the question of archives. In this regard, Financial responsibility will also be required. The retention of a small number of international judicial functions makes it possible to envisage that the president and the prosecutor will no longer be employed full-time and that they will be supported by a light administrative structure in one place. Functions than that proposed by the mechanism. Reflects the unified visions of its president, its prosecutor, and its registrar. And on this basis, we are ready to work in a spirit of responsibility on the adoption of a resolution to record these developments
Doy las gracias a la delegación.
I thank the delegate of France. Thank you for your statement. And I now give the floor to the representative of Greece.
Thank you, Madam President. Greece wishes to thank the President and the prosecutor of Serbia, Bosnia and Herzegovina, the United Republic of Tanzania and Croatia to this meeting. We further welcome the sixth review report, including the submission to the Council of a strategic plan containing proposals for concrete timelines for the transfer and completion of the mechanism to state obligations falling under the ambit of Chapter 7 of the Charter, which have not been fulfilled for a long period of time. Second, on the issue of relocation compliance with the agreement between the United Nations and Niger. Third, Greece underscores the support provided by the Office of the mechanism and agrees with its recommendations. We note in particular the proposed actions addressed to the Security Council, as well as the timeline for the transfer and completion of its functions. Greece notes the recommendations of the mechanism regarding the transfer to the United Nations Secretariat of the Office of the Prosecutor Assistance to National Jurisdictions. (2740), a small, temporary and efficient structure, together with an ambitious and concrete timeline for the transfer of the functions of the mechanism, while respecting the principles of legality steps aimed at narrowing down the available locations that could host the archives. In conclusion, Madam President, the mechanism pursuant to Security Council Resolution 1966 and subsequent resolutions has contributed while safeguarding the functions of international character and providing assistance to national authorities to render justice for victims. I thank you.
Doy la gracia a la del delegado.
I thank the delegate.
Briefings on the mechanism's continuing efforts to advance justice for atrocities committed in Rwanda and the former Yugoslavia, as well as both of your contributions to the work underway to responsibly wind down the mechanism. Effort, including the unified vision and strategic plan submitted in line with Resolution 2740. We also appreciate the mechanism's offer to provide the Council with suggestions prosecutors' national assistance functions to the Secretariat. These functions continue to provide valuable support to national jurisdictions addressing atrocity crimes success. The United States also supports the transfer of the day-to-day supervision of sentences to enforcement states, and we support the enforcement of ICTR sentences in staffing, as well as the consolidation of the very limited judicial functions that will remain to a single location. It would also be helpful to receive additional information on the expected timelines, staffing, and budget for all potentially retained judicial functions. We are committed to continuing to actively work to address these and other outstanding issues as the Council completes this review. I thank you.
Doy las gracias al delegado de Estados Unidos.
I thank the United States, and I give the floor to Somalia.
Thank you, Madam President. I thank President Santana and Prosecutor Bramett for Bosnia and Herzegovina, United Republic of Tanzania, and Croatia in today's meeting. My delegation considers this debate to be a paramount of importance as the Security Council conducts its biannual review of the
forward toward a closure of the mechanism, we take note of the proposal set forth in the Secretary General's strategic plan. The proposed timelines offer a framework for the transfer of non-judicial oversight services, which affirm that the mechanism has successfully delivered on its core mandate despite experiencing extensive budget and staffing cuts over the past 4 years. On the final Somalia reiterates its support for the small, temporary and efficient structure of the mechanism and the orderly completion of its mandate. The establishment of justice and the preservation of the rule of law remain essential elements
Thank President of the International Residual Mechanism for Criminal Tribunals, Ms. Gatti Santana, and Chief Prosecutor Brammertz for their briefings, but also for their significant efforts in support the International Criminal Tribunal for Rwanda and the International Criminal Tribunal for former Yugoslavia and the mechanism have left a lasting legacy in international criminal Nuremberg and Tokyo war crimes proceedings. And beyond prosecutions, this institution gave victims a voice. Through thousands of witnesses' testimonies. IRMCT has worked hard on completing all the remaining core crime cases. And the archives preserving all the documentation of the tried crimes, record and That is why Latvia is engaging in the review with the following priorities. First, ensure a balance between efficiency and proportionality in completing and transferring the functions of the mechanism. The IRMCT has always been temporary in nature, and it is not our goal to prolong its existence. For the negotiations. And the Council must make decisions that guarantee realistic timelines and the transfer of the archives to appropriate host countries, while ensuring broad accessibility for victims, survivors, and diaspora communities affected by these crimes. What happens? Ensuring access helps counter denial, distortion, and revisionism while supporting education, memorialization, and intergenerational remembrance. And they stand as a precedent and symbol of accountability for crimes that continue to be committed in the ongoing conflicts and wars. Third, ensure that witnesses can we must now secure this justice through the proper transfer of residual functions so that the legacy of the tribunals continues to resonate for decades to come.
President, let me begin by thanking President Gatti Santana and Prosecutor Brammertz for their informative briefings. I also welcome the Minister of Justice and Attorney General. They have delivered remains important to this day. We also note, however, that the long-term consequences of these conflicts remain starkly visible and continue to reverberate in this Council. Madam President, Denmark welcomes the progress made in the mechanism's important mandated functions despite challenging circumstances. The mechanism's extensive activities during the reporting period transition is needed in order to safeguard the legacy of the mechanism and its predecessor tribunals and ensure successful transfer into the national transitional justice processes. With of a small, temporary, and efficient institution. We are pleased to note that it contains detailed timelines for the completion and transfer of the majority of the residual functions. And we also welcome its recommendations for considerably ongoing review of the mechanism. My third point, Madam President. We urge all states to promptly and fully cooperate with the mechanism in line with their international obligations. In particular, once again reaffirm Denmark's steadfast support for the work of the mechanism and for the pursuit of international criminal justice. Our commitment to supporting the Council's efforts to combat impunity wherever it exists remain unwavering. We look forward to working with all Council members to this end. I thank you.
Doy la gracia a la delegada.
I thank Denmark.
And Herzegovina, Croatia, Serbia, and Tanzania to today's Council meeting. I also thank President Gatti Santana and Prosecutor Brammertz for their briefings and the principles of the mechanism for their reports to the Council. President, today's briefing occurs at an important time for the mechanism. It with those functions. As the President mentioned in her remarks, the mechanism has already rightly taken a number of steps in this regard, including staffing and budget reductions in recent years. However, much more needs to be done to ensure that the mechanism becomes a strategic plan presented by the mechanism's principles. The plan provides a good basis for discussions and for achieving change in a responsible manner. Turning now to some of the specifics covered in the plan, in our in relation to the archives, we thank those states that have made offers to host these materials. The UK's view remains that the mechanism's archives should be transferred to the UN Secretariat welcome the steps outlined by the mechanism in its own report in that regard. Finally, although there are historic reasons for the mechanism's two-branch structure, at this stage in its life cycle, the UK considers this is no longer necessary. In our view, stage of its remaining operations. Thank you.
Doy las gracias al delegado del Rey.
I thank the United Kingdom.
Continuity, upholding accountability, and in ending impunity for atrocity crimes. The work of the mechanism and its predecessor tribunals, the International Criminal Tribunal for the former Yugoslavia, and International Criminal Tribunal that the mechanism has concluded its core judicial and prosecutorial work in 2023, it would be appropriate to take the further necessary steps towards the
uniform treatment of the convicted prisoners. We are confident that in pursuit of this objective, Council members would explore innovative solutions for the transfer of mechanisms functions while taking while finalizing the new location of the archives, consideration may be accorded to members the horrid and painful memories of grave crimes committed against our fellow human beings. Yet, it also inspires us to exert ourselves to never allow the repetition of such grave offenses anywhere, under any innocent humans is being trampled by oppressive and tyrannical measures, and where Security Council resolutions are being brazenly ignored and flouted. Pakistan will continue to engage constructively
Madam President, China thanks President Santana and Prosecutor Bramos for their briefings and welcomes the reports submitted by the Secretary General and OIOS on the residual mechanism. We welcome the presence of Minister of Justice and Attorney General in 1966 deciding to establish the residual mechanism and defining it as a small, temporary and efficient structure whose functions and size will diminish over time. Over the past 16 years, the mechanism has contributed to international criminal justice and the prosecution of serious international crimes, and has played a positive role in promoting national reconciliation and restoring the rule of law in the countries of former Yugoslavia and Rwanda. China recognizing judicial and administrative functions have been significantly reduced. More favorable conditions are now in place for further transfer and streamlining of its functions, even for its eventual closure. The ICTY report has provided observations jurisdiction and reviewing early release and sentence commutation. China supports on the premise of ensuring fairness, justice, and streamlined efficiency the transfer of those functions to the extent should be properly preserved. The archives embody the institutional memory of ICTY, ICTR, and the mechanism itself, serving as a vital testament peoples while ensuring cost effectiveness. We encourage countries in the region to strengthen communication and consultation to develop sound and reasonable arrangements for archival preservation. Third, all parties should strengthen cooperation and coordination. They with mechanism, accelerate the transfer of functions and provide solid support for the mechanism to fulfill its historical mandate and early date. As a permanent member of the Security with these trials and have all contributed to combat impunity, achieving fairness and justice, and advancing development of international law. At this critical juncture in the mechanism's transition, China calls on all parties to reach consensus on solution and the Office of Legal Affairs for the contributions to facilitating the Council's review of the work of the mechanism. Thank you, Madam.
Thank you, Madam President. We thank Judge Graciela Gatti Santana and Prosecutor Serge Brammertz for your valuable briefings and reports. Therefore, and in line with our tradition as a party to the Rome Statute, we wish to reaffirm recognizing their fundamental role in the fight against impunity and in ensuring accountability for the gravest war crimes and crimes of genocide and crimes against humanity. Protection of victims and witnesses, and the preservation of judicial archives. Our record of support is based on the rule of law. We firmly support the decisions adopted within the framework of these tribunals, which are based on independent proceedings, rigorous proceedings, and are based on extensive seeking consensus. Panama particularly appreciates the strategic plan presented, which reflects a serious, responsible, and technically grounded approach. These measures show law, the residual legal functions, has been taken into consideration. On this basis, and given that the mechanism has concluded its main judicial role and has therefore become residual, we reiterate that the reduced nature of the work of the mechanism, which of course incurs lower costs, does not reduce the importance of the mechanism, given with the definitive closure of it. This brings with it the need to ensure that this next phase is managed in both an urgent and coherent manner, preserving its value for international justice and ensuring accountability. The legacy of the mechanism must be for it to be a benchmark, the preservation of the legal, evidential, and jurisprudence achievements of the mechanism is essential not only to properly conclude these processes, but also to serve as a basis for future international mechanisms or national jurisdictions that need to be seized of crimes of genocide, crimes against humanity, and other grave violations of international law. Madam President, Panama reiterates its support for the mechanism and underscores that the end of its mandate must also come with fully preserving its residual functions, the full validity of its legal decisions, as well as its contribution to international jurisprudence and the strengthening of international criminal law. It's essential for we owe this not only to the victims, but also to present and future generations, as part of a collective responsibility that preserves the memory, that consolidates lessons learned, and that projects the progress of international law into the future when it comes to crimes against humanity and genocide, to ensure that they never happen again and that they never go unpunished again. Thank you very much. I thank the representative of Panama for his statement. I shall now make a statement in my capacity as the representative of Colombia. Colombia thanks President Graciela Gatti Santana and the prosecutor, Mr. Serge Brammertz, and the Secretary General for your reports, which we believe are very complete and that contain specific measures that will contribute effectively to ensuring that the activities of the mechanism are transferred in an orderly manner and that the closure takes place and that it is done as carefully as possible. The mechanism is a reminder of what the international community can achieve against impunity when there is a firm, coherent, and long-term commitment to it. Colombia recognizes that the mechanism has wholeheartedly fulfilled its mandate, largely thanks to the support provided to it by member states. Today, when the mechanism that was always designed to be a temporary institution is approaching its definitive closure, the support of this Council and of member states individually at these last moments remains essential. It's essential to ensure that the legacy of the mechanism and of the ad hoc tribunals is consolidated, supporting all of the mechanisms and measures designed to disseminate the rulings and proceedings and ensuring that access to the archives is preserved and maintaining the ongoing assistance that the mechanism provides to national jurisdiction. Thanks to our experience in transitional justice and reconciliation, Colombia particularly appreciates historical revisionism and the glorification of war criminals, and would also enable the rights of victims to be protected on the long term. Generally, my country supports the proposals included in the strategic plan. That concrete dates and specific proposals are included, as well as the openness of all of the main officials of the mechanisms to engage in dialogue with members in order to discuss these recommendations, to respond to concerns, and to make suggestions. Colombia, in this regard, stands ready to discuss these recommendations in full transparency. The goal must be the definitive and orderly closure of the mechanism to ensure that it is satisfactory for all of those involved. This goes beyond the members of this council because the legacy of the mechanism ultimately is the legacy of international criminal justice. Colombia therefore wishes to reiterate its gratitude to all of those who have contributed to this process, to those who have submitted their views on the best way to transfer certain functions, and to the states that have expressed their willingness to assume some of the mechanism's responsibilities. Colombia is very clear that all decisions taken by this council in the coming 2 weeks must focus on the protection of the victims, the rights of convicted persons, and the mechanism's decisive contribution to peace, justice, reconciliation, and non-repetition. Finally, I wish to reiterate that in light of our experience, we assign the highest priority to this process, recognizing that justice is sustainable over time only when decisions are made in a transparent and inclusive manner, and when a sense of ownership is ensured for all of those who participated in the history of the tribunals and the mechanism. For these reasons, we will participate in these discussions, fully aware of the historic responsibility entrusted to us as elected members of this council. Thank you very much.
Vuelvo a asumir las funciones.
I resume my function as president of the council. I now give the floor to His Excellency Mr. Emmanuel Ugirashebuja, Minister of Justice and Attorney General of Rwanda.
Madam President, thank you for giving me the floor. Rwanda thanks President Graciela Gatti Santana and Prosecutor Serge Bramert for their briefings and for presenting the 6th review report of the International Residual Mechanism for the Criminal Tribunals. Rwanda welcomes the progress reflected in the report. The mechanism has now completed the core elements of the mandate entrusted to it by the Security Council. Madam President, Council members, over the last 3 decades, Rwanda has worked closely with both the ICTR and the mechanism in pursuit of justice for the victims of the 1994 genocide against the Tutsi. During that period, Rwanda's institutions have evolved considerably. Today, Rwanda is not merely a beneficiary of international justice efforts. It is a partner in preserving their legacy and ensuring their continued relevance. It is in that spirit that Rwanda wishes to address what it considers the most important issues before the Council. First, it is the future of the ICTR archives. Rwanda has carefully considered the options presented by the Secretary General regarding the future location of the archives. We appreciate the efforts undertaken to identify possible arrangements. However, for Rwanda, This is not simply a technical or administrative matter. Rwanda fully recognizes that these archives remain the property of the United Nations. However, ownership alone should not determine their future location. Historical relevance, accessibility, and proximity to the people whose history they document must also be taken into account. And actually, I believe these are the main criteria that the Council should base on when arriving at a decision. Unlike other international tribunal archives that relate to multiple countries and multiple conflicts, the ICTR archives concern one country, one people, and one genocide. They are inseparable from Rwanda's history. Logic, principle, and historical reality, therefore, point in the same direction. These archives should be located where their significance is greatest and where those most directly connected to them can preserve them. Rwanda has fulfilled all the requirements necessary to host the archives. It has established the required infrastructure, developed expertise in archival preservation and digitization, put in place the necessary legal safeguards, and stands ready to provide the resources required for their transfer and subsequent management, while fully preserving United Nations ownership and ensuring continued access for researchers and scholars. Indeed, relocating the archives to Rwanda would not impose an additional financial burden on member states. Rwanda is prepared to assume the costs associated with the transfer, preservation, as well as digitization of the archives. Should the archives be relocated to Rwanda, the Council and the member states will not be called upon in the future to provide any additional resources for their digitization and management. Rwanda stands ready to undertake these responsibilities as part of its commitment to preserving the important legacy for future generations. The question before the Council, therefore, is no longer one of capacity or feasibility. These questions have already been answered. The question before us is one of principle. Where should the historical record of the genocide against the Tutsi be preserved so that it remains most meaningful, accessible, and relevant to those whose history it documents? For the survivors of the genocide against the Tutsi, the transfer of the ICTR archives will not simply represent the relocation of records. It will represent the return of an essential part of their history. Madam President, a second issue that will be considered here is that the report also highlights the continued importance of the assistance provided by the Office of the Prosecutor to national jurisdictions. Rwanda welcomes this recognition. More than 1,000 genocide fugitives remain at large around the world, and continued cooperation remains essential. The expertise, institutional knowledge, and evidentiary resources accumulated over decades continue to play an important role in advancing accountability. Rwanda further strongly believes that the remaining Rwanda-related prosecutorial support functions should be situated closer to where they are most relevant and most frequently utilized. Rwanda is prepared to even host a small residual presence to support cooperation with national authorities and to facilitate fugitive tracking and ensure continuity in accountability efforts, and also, if necessary, cover the overhead costs. Madam President, the third issue that is before you is that Rwanda also reiterates its readiness to receive persons convicted by the ICTR for the enforcement of sentences, as well as its nationals who are acquitted or who have completed their sentences and continue to await a durable solution. The mechanism is familiar with Rwanda's correctional facilities and the standards under which they operate. These facilities provide appropriate accommodation, healthcare, rehabilitation programs, and independent monitoring consistent with international standards. Beyond its capacity to enforce sentences in accordance with international standards, Rwanda also has extensive experience in receiving and reintegrating former genocide convicts and other returning nationals. Over the past 3 decades, this experience has contributed to reconciliation, social cohesion, and respect for human dignity. We therefore encourage the Council to give favorable consideration to Rwanda's long-standing offer, which is fully aligned with the completion strategy and the principle of national ownership. Madam President, finally, the strategic plan before the Council rightly points to the need for greater clarity regarding the transfer and completion of the mechanism's remaining functions. The mechanism was never intended to be permanent. Its success should ultimately be measured not by its longevity, but by its ability to complete its mandate and ensure that residual responsibilities are managed in a sustainable manner. The Council has always exercised responsibility for the establishment, oversight, and evolution of the ICTR and its mechanism. The time has now come for the Council to take the next important decision. The question of the ICTR archives, in particular, calls for a decision guided not only by administrative consideration, but also by history, justice, and the interest of survivors, whose voices these archives preserve. As the Council considers the next phase, attention should focus on practical arrangements, realistic timelines, and the orderly transfer of responsibilities, including the future of the ICTR archives and other residual functions. These decisions require the guidance of the Council itself. Having created these institutions, the Council is best placed to determine how their remaining responsibilities and legacy should be carried forward. More than 30 years after the genocide against the Tutsi, Rwanda has the capacity, the experience, and the commitment to play an important role in preserving the legacy of the international justice and carrying forward the remaining work. Rwanda will continue engaging constructively with the Council members, the mechanism, and the Secretariat on the most effective way forward. I thank you, Madam President.
Doy las gracias,
I thank His Excellency, Mr. Ugira Shebuja, for his statement. I now give the floor to the representative of Serbia.
Madam President, I would like to thank you for the opportunity to address the Council on behalf of the Republic of Serbia regarding the reports before us today, including the semi-annual report on the work of the International Residual Mechanism for Criminal Tribunals and the strategic plan contained in the 6th review report. We note in particular that the strategic plan reflects the Security Council's long-standing expectation that the mechanism functions and size should diminish over time and that the completion of its remaining functions should be pursued in a timely and efficient manner. Serbia remains firmly committed to international criminal justice, accountability for war crimes, and respect for the rule of law. At the same time, we believe that these objectives must always be pursued in a manner consistent with the principles of legal certainty, equality before the law, due process, and respect for fundamental human rights. The Republic of Serbia reiterates its long-standing position that sustainability, reduced scope of mechanisms, remaining functions provides a basis for bringing its mandate to an end. In this regard, the transfer of residual functions to national authorities or other appropriate entities should be actively pursued without unnecessary delay. We particularly note the assessment, the two key functions, the investigation and prosecution of contempt and false testimony, as well as the investigation and prosecution of core crimes, can now be considered completed. In the absence of future core crime cases, we see no compelling justification for maintaining permanent capacities in these areas. Consistent with this approach, Serbia reiterates its long-standing position that the remaining Jojic and Radeta case should be transferred to its national jurisdiction. Serbia remains fully prepared to assume responsibility for these proceedings and thus contribute to effective implementation of Security Council Resolution 2740. We also note that concerns previously raised by Serbia regarding the conduct of certain representatives of the mechanism remain unaddressed. We would like to welcome the proposal that the function concerning the review of final judgments may be addressed through the early release procedure. Madam President, Serbia also welcomes the discussion on the future disposition of archives and residual functions. We believe that the transfer of archival responsibilities should proceed without necessary delay and that appropriate consideration should be given to making relevant materials available to national jurisdictions, particularly states of origin. Such material constitutes an invaluable resource for judicial authorities, historians, and researchers. In this regard, Serbia reiterates its readiness to assume responsibility for the preservation and management of relevant archival material under internationally accepted standards, ensuring security, professional oversight, and appropriate access. We likewise note with concern that certain projected timelines for the transfer of remaining functions appear unnecessarily prolonged. In particular, day-to-day supervision of sentence enforcement is already largely exercised by the states where sentences are served, and we see no evident legal or operational impediment to an earlier transfer of these responsibilities. Accordingly, Serbia reiterates its readiness to assume responsibility for the enforcement of sentences imposed by ICTY and the mechanism in full compliance with the highest international standards, including with respect to medical care, legal assistance, and independent supervision. Madam President, I would now like to turn to several broader issues concerning the enforcement of sentences under the authority of the mechanism. In Serbia's view, these issues merit careful consideration, not only in relation to individual cases, but also from the perspective of the consistent application of the rule of law and internationally recognized legal and humanitarian standards. The first concerned access to effective legal assistance. Proceedings relating to sentence enforcement and applications for early release are often legally complex and may have significant consequences for the rights of convicted persons. It may therefore be important that those concerns have meaningful access to legal advice and, where appropriate, legal representation. Such assistance cannot responsibly be expected to depend solely on pro bono engagement. The recent case of Milan Martic illustrates this concern. His request for early release was submitted through the prison authorities but did not reach the president of the mechanism. It was only following the intervention of the Ministry of Justice of the Republic of Serbia that the president became aware of the existence of that request. Regardless of the eventual outcome of any application, procedures should ensure that submissions are properly transmitted and considered by the competent authority. The second issue concerns the consistent application of human considerations in the enforcement of sentences. The average age of persons serving sentences under the mechanism is approximately 72 years, and many suffer from serious health conditions. This reality underscores the importance of ensuring that internationally recognized standards relating to medical care and human dignity are fully respected. In this regard, Serbia recalls the case of General Nebojša Pavković, who had met the conditions for consideration of early release after serving 2/3 of his sentence as early as 2020. Nevertheless, his release was approved only after a significant deterioration of his health, and he passed away just 22 days after his release. Without questioning the authority of the mechanism, Serbia believes that such cases raise legitimate questions regarding the timely and consistent application of humanitarian considerations. The same principled concerns inform Serbia's humanitarian requests relating to General Ratko Mladić. They were based exclusively on medical considerations and accompanied by comprehensive guarantees, including strict supervision and the possibility of immediate return upon request. In Serbia's view, it's legitimate to ask whether sufficient weight was accorded to the principles reflected in internationally recognized standards, including the protection of life, human dignity, and access to adequate medical care. Our purpose in raising these issues is not to seek preferential treatment for any individual, but to advocate for a system that is predictable, consistent, and firmly grounded in the principles of legal certainty, equality before the law, due process, and respect for fundamental human rights. In that same spirit, Serbia believes that the enforcement of sentences should be organized in a manner that best reconciles the interest of justice with internationally recognized humanitarian standards and the effective administration of sentences. Against this background, and noting that arrangements remain to be made for the enforcement of the sentences of General Ratko Mladić and Mićo Stanišić, the Republic of Serbia reiterates its readiness to assume that responsibility in accordance with the highest international standards and the applicable supervisory arrangements. We remain convinced that states of nationality were willing and able to provide the necessary guarantees can contribute to the effective and humane enforcement of international criminal sentences while fully respecting the authority of the mechanism. Our objective is neither to revisit final judgment nor to seek preferential treatment for any individual. Rather, Serbia advocates for a system that is principled, consistent, and firmly anchored in the values of justice, humanity, and the rule of law. We believe that credibility of international criminal justice is strengthened not only through accountability, but also through the fair, humane, and even-handed application of legal standards to all persons under its jurisdiction. I thank you.
I thank the delegate of Serbia for your statement. And I now give the floor to the representative of Bosnia and Herzegovina.
Muchísimas gracias, señora presidenta. We extend our best wishes for a successful presidency of the Council for the month of June. I wish to thank the President and the Prosecutor of the International Residual Mechanism for Criminal Tribunals for their continued commitment to the full and successful implementation of their respective mandates and for providing an overview of their activities in reports before us. Allow me at the beginning to repeat once again the importance we attach to the work and role of both the mechanism and its predecessor. For Bosnia and Herzegovina, this is not an abstract legal undertaking confined to courtrooms, judgments, and legal archives. Rather, it is a process that resonates deeply in every unhealed wound, every family still searching for answers, and every community carrying the enduring scars of conflict. The judgments of the ICTY, safeguarded and upheld by the mechanism, and the affirmation of victims' rights and experiences have helped establish an authoritative historical record and have contributed to confronting denial, combating impunity, and preserving the truth for future generations. For the people of Bosnia and Herzegovina, justice is inseparable from memory, dignity, and the acknowledgement of suffering. Madam President, the legacy of these judicial institutions extends beyond legal precedent. While recognizing that the mechanism must eventually close, it is vital to ensure the orderly and carefully planned execution and transfer of its residual functions. Doing so will honor that legacy, safeguard the credibility of the tribunals and the mechanism, and preserve their enduring contribution to international criminal justice. In that regard, we take note of the mechanism's continued efforts to reduce its mandate, workload, and resource requirements as it moves towards closure, and welcomes the strategic plan in the context of the Security Council's review of the mechanism's work in progress, building on the Secretary General reports of December 2025. Consequently, Madam President, I wish to make the following points. 1, the pursuit of accountability serves not only the interest of justice, but also the broader aspirations for reconciliation, trust, and lasting peace. And since that pursuit is now fully in the hands of national prosecutions, assistance to national jurisdictions in investigating, prosecuting, and adjudicating complex war crime cases remains vital. To that end, the next few years will be critical to delivering more justice for war crimes in Bosnia and Herzegovina, and as we remain confronted with a large number of challenging cases, keeping the caseload heavy and on the rise, and we will remain reliant on the invaluable expertise, support, and strategic advice of the OTP in completing our goal. Given the Secretary General's recommendations as to the transferability of the prosecution's role in carrying out this mandate, we support a rational and responsible timeline for the proposed transfer of OTP's assistance functions to the Secretary General to be assigned to the appropriate entity that will continue to execute this function expertly, urging that it is also accounted for the appropriate transfer of specialized expertise. 2, we further support the transfer of the day-to-day supervision of conditions of imprisonment to member states where convicts are serving their sentences, which already oversee convicted persons on a daily basis. It will positively reflect on the resource requirements of the mechanism, as well as the administrative and financial obligations related to sentence enforcement. However, the authority to order the transfer of prisoners, designate enforcement states, and decide on application for pardon, commutation of sentence, and early release should remain at the international level, with the continued involvement of the President, the mechanism judges, and the essential support staff. It provides neutrality, insulation from local political pressures, and uniform treatment across cases in accordance with international standards, helps safeguard against actions that undermine established judicial facts, including genocide denial, the glorification of perpetrators or revisionist narratives, and ultimately prevents convicted individuals from benefiting from political influence within their home states or states that they may be sympathetic to. On that note, allow me one additional comment. It is always fascinating from a standpoint of credibility and moral integrity to listen appeals on behalf of convicted war criminals and genociders for their early release. Today we heard a new one, appeal for more elementary humanity. For the sake of clarity, we're speaking here of the butcher of Bosnia, butcher of over 8,000 innocent people in Srebrenica, one who ordered the indiscriminate and merciless shelling of Sarajevo for 1,425 days, and his name is Ratko Mladic. I wonder if they ever looked into the eyes of a mother who lost her sons, or the one who watched a daughter being repeatedly raped, or the one who lost an entire family, with similar compassion and concern as they do for the monster that committed these crimes. At least once he is dead, he will have a grave, a tombstone, something to mark his remains, however despised. Many of the mothers died without ever being able to bury at least a bone of their children. So let me ask you, what humanitarian grounds are we speaking of? Was he concerned about anything remotely humane in relation to the crimes he was convicted of? Upon entering Srebrenica on 11th July, Ratko Mladic boasted that the town was now liberated for the Serb people. And I quote, "Here we are on the 11th of July in Serb Srebrenica, the day before one of the greatest Serbian holidays. We give this town to the Serbian people. The moment has finally come after the uprising against the Dahi or the Turks to take revenge against the Turks in this place," end of quote. And these are his words, not mine. This is not artificial intelligence. It is well recorded on cameras following his every move. Did he ever apologize? Did he ever atone? Did he by any chance divulge the location of mass graves? Did he ever offer any indication of regret? On what should we base the compassion for his early release? We have every faith in explanation given by President Santana for refusal of Mladić's early release. On all accounts, the Mandela rules are fully respected. The same could not be said for those he imprisoned and executed in Srebrenica. So let me be clear. We wish him a very long life, at least long enough to account for at least 8,000 innocent people he mercilessly sent to death. That is all in terms of compassion we can muster. Now I return to the remainder of my statement. The archives of the ICTY and the mechanism constitute an authoritative and irrefutable record of the recent history of my country. Moreover, Bosnia and Herzegovina still relies heavily on ICTY archives, evidentiary databases, witness materials, and legal findings developed over decades of prosecutions. Proper transfer and accessibility of these materials are essential for ongoing domestic proceedings against lower and mid-level perpetrators who were never prosecuted internationally. These archives constitute an invaluable resource whose significance extends far beyond their legal function. While they preserve the evidentiary record of investigations, prosecutions, and judicial findings related to serious violations of international humanitarian law, their importance is equally profound for education, historical research, and the promotion of truth and accountability. Moreover, with proper preservation, management, and accessibility, they will provide scholars, educators, journalists, and future generations with access to authoritative records, testimonies, and judicially established facts, contributing to informed dialogue and critical inquiry, as well as a deeper understanding of the causes, dynamics, and consequences of mass atrocities, thereby supporting a deeper appreciation of international justice and the rule of law. In that regard, we emphasize yet again that maintaining and facilitating access to the ICTY archives is of lasting importance, not only for the purposes of justice, but also for advancing education, historical research, and the broader objectives of peace, dialogue, and respect for human rights. In terms of regional cooperation, challenges remain. Many suspects are not present in the territory where they are alleged to have committed the crimes, creating significant obstacles to effective investigation and prosecution. To overcome the burden of the past, we must pursue justice and accountability with renewed determination and in good faith. Political considerations must not hinder the pursuit of justice, nor should they obstruct victims' rights to truth, justice, and redress. Not to mention that 3 decades after the war in Bosnia and Herzegovina, more than 7,500 families are still searching for answers about their missing loved ones. Despite legal frameworks and international support, political barriers and time threaten to leave these stories unresolved forever. Effective regional cooperation is not only a legal necessity, but also a moral and societal imperative. By demonstrating a shared commitment to accountability, states can help build public confidence in judicial institutions, counter denial and revisionism, and foster a common understanding of the facts established through judicial proceedings. Finally, Madam President, we urge the Council to remain committed to supporting this transitional phase in this final and important stretch, based on respect for international law, in a way that guarantees the completion of the mechanism's mandate, preserves the integrity of the judicial process, and safeguards its legacy. Thank you.
Doy las gracias.
I thank the delegate of Bosnia and Herzegovina. I would like to remind all speakers to limit their statements to a maximum duration of 3 minutes so that the Council can deliver its work expeditiously. I now give the floor to the delegate to the United Republic of Tanzania.
Madam President, Your Excellency, distinguished members of the Security Council, I thank you for inviting us to this important debate and the opportunity to share with the Council our views regarding the future of the International Residual mechanism for the criminal tribunals. I commend the president of the mechanism, Judge Graciela Gatti Santana, the prosecutor, Serge Brammers, and the Office of Legal Affairs for the job well done so far. And we welcome the strategic plan and the proposition therein. Following the Secretary General's report, and particularly the call to interested member states to express interest to becoming the long-term host of the archives, the United Republic of Tanzania formally expressed its interest and readiness to serve as the long-term host of the archives of the International Residual Mechanism for the Criminal Tribunals. This is reflected in paragraph 66 of the Secretary General report contained in the document S-2025-785. In our submission, we will stick to the future of the IRMCT archives in Arusha and submit to you 3 main reasons for our humble request. Madam President, number 1, we wish to remind this Council that the United Republic of Tanzania hosted the International Criminal Tribunal for Rwanda, ICTR, for 20 years, from 1995 to 2015, and the residual mechanism for more than 10 years. This totals 3 decades, or to put simply, 1 generation or 1/3 of a century. During all that time, the tribunal and archives have been kept safe and secured in a neutral country that ensured proximity to the affected population and unhindered access to all, I mean researchers, legal scholars, historians, and defense teams from all over the world. We have already proven by words and deeds to be a good host. Second, the United Nations and the government of the United Republic of Tanzania have already heavily invested in state-of-the-art infrastructure in Arusha. The United Nations alone spent $6 million on a facility specifically engineered to preserve massive physical records and digital infrastructure. Moving these fragile historical assets will carry a logical risk and render a world-class facility redundant. On our side, the government alone invested around $2 million, which includes the provision of 16 acres of the prime land and the installation of supportive infrastructure for the facility, including building a tarmac road to the facility. This is evidence of us living up to our promise and to your expectations. The only thing we request of this Council is to consider the investment already made and the commitment and trust our government has shown so far. Third, the government of the United Republic of Tanzania has formally and in writing committed to the Secretary General through writing our readiness and willingness to meet the cost of maintaining the archives in Arusha. And this means if this Council decides the archives are to remain in Arusha, there will be no cost of transferring them. So far, the report estimated at $1.8 million. There will be no future cost of maintaining them where they are in Arusha. And there will be no switching and hidden costs that may arise in that complex logistical operation. So to say, the United Republic of Tanzania is offering a stress-free, a cost-free, and a timeline-free solution to this Council, while guaranteeing a long-term preservation, security, accessibility, and institutional independence of the archives. Madam President, Tanzania attached great importance to this matter, not as a national priority, but as a contribution to the broader interests of international community and the region. Much as the archives are about a particular country, the fact is they are primarily the United Nations repository and the common heritage to all humanity. We believe these archives constitute not only a repository of history and legal significance, but also a vital resource for ongoing and future efforts in accountability, reconciliation, and the promotion of rule of law at national and international levels. After 30 years of hosting both the International Criminal Tribunal for Rwanda and the International Residual Mechanism, Arusha branch, we have been tested and proven our goodwill, our good faith, and our good intent. We appeal to your Council to accept our bid to become a long-term host of the archives. This will be a strong gesture of appreciation for our modest contribution and the role well played in promoting international law, international criminal justice, and international accountability. Madam President, we are ready, we are willing, and we are reliable. Thank you so much for your kind cooperation.
Doy las gracias.
I thank the representative of the United Republic of Tanzania, and I give the floor now to Croatia.
Thank you, Madam President. I would like to also thank the President of the mechanism, Judge Gatti Santana, and the Prosecutor Brammers for their reports and today's briefings. Croatia supports the efforts to identify the most suitable and efficient way for the timely completion and transfer of the mechanism's functions. In that context, we welcome the mechanism strategic plan, including its recommendations concerning the transfer and completion of all remaining mechanism functions. We also recognize it is essential to ensure that its future closure is carried out in a constructive way that will not, in any respect, undermine the purpose for which the mechanism was established. Croatia supports the continued exercise by the mechanism of the 4 judicial functions currently under its mandate, namely the early release, variation of protective measures, non bis in idem, and referral. Madam President, regarding the future location of the archives, Croatia reiterates its readiness to assume responsibility for the preservation of the archives of the ICTY and the mechanism, and to serve as long-term host of the United Nations entity responsible for their maintenance. To this end, suitable premises that meet all necessary technical, security, we also recognize that safeguarding the integrity, authenticity, and credibility of these archives is essential for enabling researchers, institutions, and other stakeholders to effectively address persistent attempts at historical revisionism and to preserve an accurate historical record for future generations. Confidence in their impartial stewardship, long-term preservation, and accessibility. This decision will carry significance well beyond administrative arrangements, given the archive's important role in timely resolution of investigative and judicial cases. The cooperation in every case should meet international legal standards and established good practices. As the fate of 1,725 missing Croatian citizens remains unresolved, establishing the truth about their whereabouts and ensuring that they receive a dignified burial remains a matter of profound importance and a long-standing priority for Croatia. Regrettably, the absence of sufficient political will and of missing persons has been achieved almost exclusively through the sustained efforts of Croatian institutions and experts, despite the fact that many records and sources relevant to these cases are likely to readily be accessible to authorities in Serbia. This makes the continued lack of cooperation all the more difficult to justify. A stronger engagement and greater readiness of Serbia to share available information would significantly contribute to advancing these efforts. Every delay further prolongs the suffering of families who have waited for decades for answers and closure. Croatia therefore encourages the mechanism to continue giving due attention to the issue of missing persons and to support all efforts aimed at advancing
The representative of Serbia has asked for the floor to make a further statement. I give them the floor for the second and last time.
in the former Yugoslavia and the suffering endured by victims and their families. Those wounds remain deep through the region. Serbia is equally aware that painful memories and competing narratives continue to exist. They exist not only among Bosniaks, but also among Serbs, Croats, and other communities in Bosnia and Herzegovina, as well as across the region. However, this debate should not become an arena for competing narratives or historical grievances. As said, our statement today is not about revisiting judgments, questioning criminal responsibility, or diminishing the suffering of any victim. The issue we have raised is a legal and principled one. A system based on the rule of law is distinguished from a system based on retribution precisely because punishment is administered within the framework of law and with the full respect of fundamental rights. The deprivation of liberty constitutes the punishment imposed by the court. It does not extinguish the obligation to treat every individual humanely or to respect internationally recognized standards. That principle is reflected in the Nelson Mandela rules, in international human rights instruments, and in broader legal traditions shared by the United Nations. These standards are universal by design. They do not depend on the nationality of the convicted person, of gravity of the offense, or the emotions that understandably surround particular cases. When Serbia referred to humanitarian requests in specific cases, it did so to illustrate broader legal principles. The same standards and the same legal principles should apply to any convicted person in comparable circumstances. Finally, Serbia rejects any suggestion that advocating for the consistent application of international legal and humanitarian standards amounts to celebrating crimes or denying justice to victims. Serbia has demonstrated its commitment to accountability through its undeniable cooperation with the ICTY. Our position today is entirely consistent with that record. We remain convinced that the credibility of international criminal justice depends on its ability to combine accountability with scrupulous respect for the rule of law, due process, and fundamental rights that international law guarantees to every human being. Justice and humanity are not opposing values. They are complementary pillars of the same legal order, and preserving both is essential to maintain confidence in international criminal justice.
There are no more names inscribed on the list of speakers. The meeting is adjourned.
you.